start because we have a busy schedule, as you may have noticed. Today, we experiment with a new format, which is allowing speaker 10 minutes if they only provide one slide or one sheet of paper in advance, which all chose to do today. So I guess we'll have presentations of up to 10 minutes from each, and then followed by 20 or something less minutes of discussion, Q&A. And without further ado, I would give the floor to Abby and Jeremias for their section of the seminar.
Great, thank you very much indeed. Can you all see the screen share? Perfect. So right before we get going, we've actually thought we'd do a little interactive bit and involve all of you, because we'll be talking a lot about data, and so we're also going to use this to collect some data from you. So in your browser, please, could you go to www.menti.com, the address that's on our slide at the moment. And then that website will ask you to type in a code to get to our survey, and the code is 246460. And then while we do the introduction, just answer the survey. We can guarantee you it's all anonymous, but we'll be able to show the aggregated results from everybody on the call in live time in a moment. So I'm Jeremiah Adams-Prassel. I'm a professor in the Faculty of Law, and I'm presenting with Abby Adams-Prassel, who's a senior research fellow in the Department of Economics, both at Oxford University. And we'll be drawing on data that Abby has been collecting on the labour market impacts of COVID-19 in real time, both in the US, the UK, and Germany, together with colleagues from Zurich University and Cambridge University. And really, when we look at that impact it's had on the labour market, the one key theme that we see is that the impact has been terribly unequal. And there's three dimensions of this inequality, which we briefly want to talk about to you today, both quickly exploring the data and then thinking about the legal implications for labour market regulation. And those inequalities are first, the impact on working from home. Second, inequalities in terms of contract types and different employment models. And finally, stark inequality in terms of gender and other protected characteristics.
So to illustrate some of the inequalities that we've seen in terms of the impact of working from home, okay, let's just have a look. What we want to do is just look at, so how much can all of the people on the call work from home, and then compare that to actually in terms of the average UK worker, how much can they do from home? Okay, so these are the results from you know, all of you guys, and also some data that I collected in a survey in a presentation last week. So the blue bar, so that gives us the kind of average proportion of our jobs that we think we can do from home. So perhaps unsurprisingly, given all of us are listening in to Zoom at this moment, we can do a very high percentage of our jobs from home. So on average, 90% of our jobs from home. Now, what we're also interested though is what are our perceptions about the average UK worker, and actually just to kind of illustrate the fact that we're in a very privileged position. So what we think in terms of on this call, people think that the average UK worker can do about 38% of their job from home. Okay, so basically you are spot on. I'm very surprised and you all feel very pleased with yourself. So what we find is that across the UK, the US and Germany, about 20% of people say they can do absolutely none of their jobs from home. And on average, the average worker can do about 40% of their jobs from home. So people are spot on here. But the reason why this is such an important issue that we wanted to raise is just because of the impact that working from home, the ability to work from home has had on your labour market outcomes. So those who find it easier to work from home are much less likely to have lost their job, suffered any hours losses, and suffered any earnings losses. So in terms of, and this is, it's not just important for understanding the impact right now, this impact is also important for thinking about future legislation and regulation responses.
And so here in particular, the kind of things that we're thinking of that this kind of data can inform refers both to health and safety legislation in the short term, but also in the longer run in terms of thinking about this mooted introduction in various jurisdictions of something along the lines of a right to work from home. So quickly, to give you an idea in terms of health and safety, already we've seen some very serious implications of reports of people, even though they're sick, they're displaying symptoms of COVID, continuing to work because they can't work from home. And this ties in with our next point in a moment, they don't have any other source of support or income. So it's a health and safety issue, not just necessarily for the worker itself, but also for all her customers and clients who she might encounter in terms of going about her job. Think about deliveries in particular, for example. Related to that, as we now started to move into a world of returning to work, there'll be some serious questions about the health and safety implications of this and their quite starkly split impact on the income distribution. And so yesterday, for example, you've seen the Financial Times did various elements about the fact that actually health and safety inspection, long decried as sort of, red tape imposed on us from Brussels, has actually been seriously reduced. And so there's some really hard questions coming up in the medium terms in terms of inspections. In terms of the right to work, which BEIS is looking into introducing quite actively, prima facie, that's very attractive, right? Prima facie, that increases employee choice over the workplace. People don't want to go back. But also at the same time, we have quite a lot of evidence of late working, of very long hours working. So it'll be a real challenge in terms of applying regulatory measures, such as, for example, the working time regulations or various, again, employer obligations related to stress and work-life balance, and how that could work out if we introduce this new right to work from home.
So the kind of second key theme that we found in all of our surveys has been that it's not just your ability to work from home that matters. It has also what type of labour market contract you're on has also had a big influence in the relationship with job loss and earnings loss. And perhaps unsurprisingly, those on more insecure contracts have been hit much harder in terms of the economic fallout of the containment measures. Not on the slide that, well, actually, so this graph we'll circulate our paper later, which has all of the full results in. But we see that both in terms of the self-employed, those who are on temporary contracts, and those who are on 0 hours contracts or contracts where their hours vary and at employers' discretion, are much more likely to have lost their jobs, much more likely to have suffered earnings losses.
And in terms of the legal implications, I think it's long been clear that within Europe, the UK has had by far the most flexible and deregulated labour market, much closer to the US structures in most states than continental Europe. And what we're really seeing here is that this, suspicion and argument that many of us have been pushing for a while, that actually, whilst this is often sold as a notion of flexibility, the reality is that these flexible forms of work are in fact extremely one-sided in terms of the flexibility they offer. They're essentially employer-sided flexibility. And what ends up happening is essentially huge amounts of risk end up being concentrated on the individual worker. And that's exactly what we're seeing here now with COVID as that particular risk. The other interesting point, and then we suspect Judith will talk more about this, is that when you look at the impacts across different contract types, actually a lot of those people on flexible contract types, the impact looks much closer to that we've seen on the vast majority of the self-employed. So again, when it comes to this equal treatment that we and Judith and others have been calling for a long time, there's clear evidence that in terms of contract types, a lot of these flexible employed people actually are much closer to the economic reality of a lot of self-employed people. And the final point we want to talk to you about briefly is gender and the implications this will have in particular for equality law, both in terms of public sector equality duty, but also employers' equality duties in ensuring equal treatment in the workforce. Because again, we see extremely stark differences in the data.
So what we find in the US and the UK is that women are more likely to have lost their jobs, and those women who have kept their jobs are also more likely to have been furloughed. Now, when we first started looking into this, our prior was that this gender difference was going to be fully explained by the fact that men and women do different types of jobs. So traditionally, actually, recessions usually hit male-dominated industries hardest. If you look at the financial crisis, for example, that's what happened. However, the kind of bizarre nature of this economic shock means that actually female-dominated industries have been hit hardest in terms of, the impact on service sector lockdowns. However, even when you control for occupation, for industry, for contract type, women are more likely to have lost their jobs or to have been furloughed. And we find this kind of incredibly striking. One of the things that obviously is also different about this economic shock compared to others is the relationship with domestic responsibilities and childcare, given the closure of schools. And what we find is that the gender gap in childcare hours has actually increased over this crisis. So whilst it's true that now men are report doing more active childcare on a typical working day than they did before the crisis, women's burden has increased even more than that of men. And I think that, in terms of understanding what this means in terms of long-term, long-term pattern of gender differences in the labour market, this is very important to us to get to the bottom of what's going on here.
Good. And so before Luca cuts us off, I think that's our 10 minutes done. Thank you very much indeed. We look forward to your questions.
Thank you, Abby and Jeremiah. So the floor is open to questions. You can use the Q&A function, the chat function, either to raise hand, writing hand, or to insert your question, or you can also raise your hand. Anyone?
May I ask a question?
Hugh.
A slightly different question, and that is whether you found any groups who are particularly hard hit because they fall between the various stools of government support. For example, we have a scheme for the people who are employed. We have a scheme for agency workers. We have a scheme for the self-employed, but people who paid themselves by dividend, I've heard, somehow don't get covered. I wondered whether you had uncovered any particular gaps.
So we haven't been able to look at that particular gap. One thing we've been looking into is the fact that some of, for example, the furloughing scheme and some of the support to the self-employed is dependent on when did you start your job, basically. And so what we have been looking at is the duration. So are there particular groups in terms of who changed job recently and then fell between the cracks with the furloughing scheme, and also groups of the self-employed who also fall between the cracks. I can't tell you exactly those numbers now, but that is something that we are looking into and have been asked to look into for BEIS. One of the issues is that so whilst we've surveyed 28,000 people so far, it's still, when we get down to these very small, once you start kind of going down within the self-employed and looking within variation there, we sometimes don't have a huge sample size to come to definitive conclusions. But what we're hoping to do is kind of flag particular issues for things like the labour force survey, for the family resources survey, such that and the understanding society survey, such that then we can get in those surveys, they make sure they're kind of targeting questions at the right groups.
And again, Hugh, I think from a broader sort of regulatory perspective, I think what it shows up is that the problem with a lot of labour market regulation is still that it's designed around certain stereotypes, right? It's designed around, a permanent blue collar or white collar job that's long-term and open-ended. Self-employment is designed around certain expectations of high income, high market power. And I think what we're seeing here is that precisely in the early steps of both the furlough scheme and the self-employment support, again, I think sort of design fell into some of these stereotypes. Now, you might say, fair enough, because actually, even though lots of us are interested in atypical work, typical work does still present a very large part of the UK labour force. But on the other hand, I think it leads to precisely these kind of situations where people who might be transitioning or people who might be in some sort of different setup fall between the cracks.
Thank
Judith,
you.
I saw your hand as well, Judith.
It's mine.
Ah,
Are you ready for a question?
go ahead.
Right.
Oh,
So,
there you are. Sorry, but you hadn't showed up on our screen.
am I on the screen?
Yes, we can see you
Yeah.
now.
Okay, good. Look, talking about the flexibility of regulation, I wondered whether working time wasn't a candidate for this going forward. I mean, if we think going forward, there's going to be more working from home, then it seems to me a major distinction is not between home workers and people not working at home. It's a distinction between people working at home who can be monitored and those working at home who cannot be monitored, or it's not easy to monitor. So in relation to the latter group, I just thought one of the advantages for them is the ability to shift in and out of working quite frequently during the day. And therefore, if you're going to try and apply the current definition of working time to that group, that's going to be quite difficult. So I wondered if monitored versus not monitored workers was going to be an important category in the future.
Well, yes, Paul, absolutely. And to some extent, of course, it already is recognized in the working time provisions that that's the truth, right? So most of us on this call will not be subject to any provisions precisely because the very legal category is unmonitored working time, right? And so exactly that kind of flexibility that say an academic working by herself at home might have, subject to various sort of caring obligations, which Abby can talk about in a moment, actually that has always been unmonitored working time. I think it raises a related point though, and that is precisely this kind of monitoring and that sort of very invasive monitoring. So already before the onset of the crisis, there had been a trend towards automating various kinds of employer functions, right? This is sort of my larger work project more generally. Employee surveillance, exercise of control functions. And that industry has had a huge boost through COVID. So software that was previously used only in call centers or other fairly limited settings is now suddenly being rolled out to computers all across the socioeconomic spectrum.
Yeah, just actually briefly on, I guess, the importance of this moving in and out of work during the day. So work that I was actually doing pre-COVID was looking at gender differences in online in online work. And what you see is that whilst basically, so women who work at home, their work patterns are much more fragmented than men. And unsurprisingly, it's only really with women with children that this respects. But I think the point you raised, Paul's like a really important one as well for understanding, gender differences in the labour market going forward.
Can I draw your attention to two questions? One is in the chat from John Bowers. Can you say more about how a right to work at home would be formulated? And then Luna Shehayeb asks in the Q&A, were you able to make any conclusions on the implication of this gap on the status of women workers during the transition period back to normal? How long will these effects last?
How should we do it?
Do you do the second question?
Shall I, just while we think, I guess, about the right to work one, on the second, so what we do know from previous recessions is that job loss has a very, very persistent effect. So I think there are kind of two things potentially to think about. So the fact that women we found to be more likely to lose their jobs. We know that has a big impact on employment progression for a long time. The other thing is in terms of being able to move quickly, but if people do want to move quickly back into work now, so job vacancies across the board are down by over 40%. The only occupations where you see and some stability or growth in job vacancies are cleaning, social care, and kind of various types of health, kind of health practitioners. So if you think as well about women who might, people who've lost their jobs, the ones that they can get are typically quite high risk jobs, high risk and low wage jobs at the moment. Then the second kind of aspect, I think, which is kind of interesting for long term, like the long term perspective, is both what does this mean in terms of the burden of childcare responsibilities more broadly between men and women, and given that we've seen this increase in the gender gap in hours on childcare through the crisis, to what extent does that persist, and are there any kind of changes in norms there which might hinder women's moving back into the labour market even once schools are back? The second thing is actually brings back onto the working from home. So working from home, we can think of as, or the ability to work from home is, potentially brings lots of benefits, lowers the fixed costs for women with childcare of actually entering into the labour market. But the fact that work is done within the home does not mean that the childcare responsibilities and inequalities in home responsibilities suddenly disappear. And so what we see is this emerging body of evidence that even when work is done within the home, of course, actually, it's still not the case that men and women are necessarily participating in equal terms. So women, as I said, have more fragmented work patterns at home, which can increase, which impacts on productivity and the types of jobs that women feel able to do at home. So I think it's without being too depressing, I think that, anyway, we're going to see some persistence of this negative gender effect, definitely in the short run and potentially longer so.
John, in terms of the right to work from home, I think the answer is how would you do it? It's both very straightforward and fiendishly difficult. In one sense, I think it's very straightforward because you could use a template, like, for example, at the moment, the statutory right under the Employment Rights Act 1996 to request flexible work. And so you could try and set up a similar process to that, where essentially employees will be given a statutory right, perhaps after a certain qualification period or threshold, to actually request this right to work from home. And whereas at the moment say that it's only the right to request it, and then the employer is just under duty reasonably to think about it, you could beef that up, right? And so rather than the right to request, it could actually become the right to do this, subject, say, to an impossibility or certain remaining managerial prerogatives. So that's, I think, the easy bit. The much harder bit, I think, will be how you then weave that in with the existing framework of other statutory provisions, right? So, for example, we've already talked about working time. So you could say that, somebody at the moment who works in an office who has measured working hours, you could, for example, link the request to work from home to being shifted for purpose of working time provisions to unmonitored, unmeasured working time. That could be quite straightforward. Much harder, other things, thinking about minimum wage, how various of the employer's health and safety duties suddenly apply. I think those are the bits where it get very fiendishly difficult. So I think, in short, introducing the right is pretty straightforward. Then conditioning how it interacts with the other corpus of employment rights legislation, that will be the much harder question.
Horst, would you like to formulate your question live, or shall I read it?
I can. Thanks for giving me the opportunity to ask a question. The question I put in the chat is this: is there any data on the productivity of working from home versus working in the office?
So at least within economics, the big study that was done a couple of years ago found on average a productivity increase for workers who are working from home. However, that was for call centre workers, and the subset of workers that were chosen to participate in the randomised control trial had already been pre-selected by the firm to be those who they thought would be productive working from home. There's kind of emerging, again, more experimental evidence, which is showing a kind of a much more nuanced picture about, for certain groups of workers, it being a positive, for others, particularly those with care responsibilities, or those who, for example, don't have the space at home or the prior resources in terms of like actually having a well-stocked home office. That unsurprisingly for those groups, it seems much more much less clear. The other thing I think which is kind of tricky here is actually the measurement, if you like, of productivity, both in like a so I think in a static sense we can think about of the particular tasks that individuals are doing right now across different occupations. That's going to be harder or easier to actually measure how well people are actually performing those tasks. But then also we think about a dynamic sense, okay, so the fact that what happens if all of us aren't co-located in terms of thinking about new ways of doing things, and kind of the creativity, or actually the kind of the more I guess long-term dynamic growth of businesses. I don't think there's at least I don't know of evidence there, but it's definitely something which I think it will become a big topic right now.
Thanks.
John?
Hi, it's just a silly question, but maybe it's based on my concerns as to whether I'm getting homeschooling right. Does this suggest that families are on average spending about 4 hours on homeschooling a day, parents? Is that how I should read this?
So one of the, we haven't been able to ask, we only ask one, we don't ask about partners. Okay, so this is, so it could, but yes, if you think that people aren't, yeah, so that would suggest that if we think about, there's nothing weird going on with how people are answering, yes, that would be right. Which yes is less than a typical school day. There's a report, so just because we wanted to focus in our surveys on the labour market impacts, and also understanding better people's preferences for working from home, and actually some of what Horst was just saying, actually how do people think about the their long-term expectations of productivity and career progressions if they are working from home. We couldn't ask in more detail than we have about childcare. If that is something of interest, the IFS have asked both members of couples about how much time they're spending on childcare and homeschooling, and I found big inequality across the income distribution in terms of the amount of homeschooling that's occurring. The other thing that they look at is, has there been any difference according to whether, for example, gender differences according to whether like men have lost their job versus women have lost their job, and that kind of and those kind of trends.
I don't see questions right now. If I'm missing anyone, please jump in. And there is a comment, an old comment by now from Judith that tells us that she will get back to the issue of directors and dividends in her talk later. So, well, the time is now. If you have additional questions on Abby and Jeremiah's presentation. If not, then there is a slight change in the program, because Alice will go first on the tax section of this workshop. So thank you, Abby and Jeremiah, for the great presentation.
Thank you. And if you Google COVID Inequality Project, you'll be able to find the website that has the full papers with all the data and all the information for you.
Great. Thank you. So Alice, you have your own slide that you can
Should I share the screen? Yeah, I can.
If you like, yeah. You are sharing it, yes.
Yeah, you can see it, right?
Yeah.
Okay, that's great. Thank you for the invitation, and hello to everyone. I'm very happy to be with you today. I was lucky to work on the topic of tax and COVID with John and Richard, who are also on the call. So feel free to ask them questions after the short presentation. We wrote a short article that will be published shortly in Intertax, and today I would like to give you a brief overview of our analysis. So as a first step in our article, we've decided to compile the different measures that have been adopted and or proposed as a response to the pandemic. We've grouped these measures on the basis of their policy objective in order to be able to think about them more clearly and evaluate them. And then as a second step in the paper, we've analyzed some measures in more details due to their particular interests. For this presentation, I've chosen to focus on 3 specific measures to give you a flavor as to how some of those tax responses to the current crisis reveal some pre-existing problems that characterize our international tax system. So I'll start first with the different categories of measures that have been adopted so far or proposed as a response to the pandemic. And to classify those measures, we've decided to think about them into 3 different periods of times that corresponds to 3 phases of the pandemic. So in the first phase, and hopefully the slide, in the first phase, which corresponds to the acute overall disruption, 4 main types of tax measures have been adopted. And again, we classify them according to their objective. So first, countries have adopted tax measures in order to boost cash flow. For example, many countries have adopted tax measures that modify the temporal application of the tax system to give businesses more time for making tax payments. In some countries, the scope of these measures have been limited to companies that are not located in tax haven, whatever that means. And that's one point on which I'll come back later. Second, countries have adopted tax measures aimed at encouraging certain behaviors. For example, reduced VAT rates in order to encourage higher consumption level. Third, countries have adopted tax measures directly aimed at supporting health priorities. Think about the exemptions for VAT and customs duties in favor of vital medical equipment. And finally, countries have adopted measures aimed at providing legal certainty given the great uncertainty caused by the sudden immobility of taxpayers. The main example of legal uncertainty caused by the crisis relates to the tax treatment of cross-border situation. Suppose that you are resident in the UK, but you work in Paris. Suddenly, because of the crisis, you are required to work from home, and that could potentially have significant consequences on your tax liability. So some countries and the OECD have already issued guidelines to clarify these situations. Let's move to the second phase, which corresponds to the slow economic recovery, which starts at the end of the most severe restrictions. And in this phase, 2 main types of measures have been proposed. First, the idea is to make the transition from phase 1 to phase 2 as smooth as possible. In other words, the measures adopted in phase 1 should ideally be extended into phase 2 and then gradually terminated. Second, in this phase, it might be beneficial for countries to consider the adoptions of new tax measures in order to boost long-term investment and increase consumption levels. This leads me to the third phase, the long-term recovery, which hopefully will come sooner than later. For this phase, there have been few proposals made in the literature, including proposals to introduce wealth taxes, environmental taxes, and excess profit taxes. Excess profit taxes are taxes that would be imposed on those companies that have been exceptionally profitable during the crisis. So now that's the panoramic view of the main tax measures that have been adopted by some countries and or proposed or discussed in the tax community. What I'd like to do next is to zoom in on some of the most interesting aspects of the tax debate. So I'll focus on 3 issues, as I said before, which illustrates that the international tax system was in a crisis well before the COVID-19 crisis. And I'll try to show that some of the tax measures that have been proposed are quick fixes that are unlikely to provide long-term effective solutions to the fundamental weaknesses that characterize the taxation of corporations under domestic and international tax law. The first interesting issue concerns the proposals to tax benefits to the conditions that companies should not be located in tax havens. because allegedly those companies would not pay a fair share of tax. Although one can sympathize with the political objective underlying those proposals, they are problematic for a number of reasons. And that's particularly the case when the application of such proposals is left to leave significant discretions to tax authorities. The definition of tax havens, or what should constitute a fair share of tax, is ambiguous. And there have been some lists of tax havens released by countries or so-called non-cooperative jurisdictions, but they're often based on political rather than technical tax criteria. So it implies that the rule could catch companies that are located in so-called tax havens, but that are not engaged in aggressive tax planning behaviors. Could also imply that the rule will not catch companies that are relying on aggressive tax planning behaviors but are located in countries that are not on the list. And moreover, the rule will not catch companies using tax avoidance strategies at the domestic level. So in other words, proposals to exclude companies in tax havens from tax benefit will not solve the problem of profit shifting and aggressive tax planning, because these proposals do not address the fundamental weaknesses that characterize the corporate income tax system, namely the fact that companies can erode their tax base and shift profits from one jurisdiction to another. A second interesting question is the point on the slide related to legal certainty. So as I mentioned before, legal uncertainty mostly arises in the context of cross-border activities, and some government and organizations such as the OECD have issued guidelines to clarify how double tax treaties should apply in the context of the pandemic. Cross-border activities concern individuals. I gave you earlier the example of these persons working in Paris and living in the UK, but they also concern companies. I don't want to go into the details on how profits from multinational companies are allocated between countries. These questions are highly controversial and technical, and Richard has a much more extensive knowledge of these issues than I have. But roughly speaking, most double tax treaties rely on the assumptions that there is a functioning market, and the profits of multinationals are computing by using comparisons with independent enterprises. So in the context of the COVID-19 crisis, there is no functioning market, which causes huge uncertainties for companies that rely on cross-border activities with respect to their tax liability. As I said, the OECD has been working on guidelines which might reduce these uncertainties, but there is no certainty that authorities will follow the OECD guidelines. Moreover, these technical responses to the uncertainty caused by the crisis do not solve the pre-existing weaknesses and uncertainties that characterize the most common rules that are used to allocate taxing rights on cross-border activities, on the profits from cross-border activities. So I'll go on with the third interesting point, which concerns excess profit taxes on companies that have been more profitable during the crisis than under normal circumstances. And we can think about Zoom. It's probably a good example of such a company. There might be good policy reasons in favor of these proposals. Generally speaking, economists consider that one-off windfall taxes are efficient, by which they mean that these taxes will not distort real behavior with the economic consequences that it brings. However, in practice, it might be difficult to define excess profits. It's hard to define at the domestic level, but it's certainly harder in an international setting, given the room for profit shifting that has not been removed from the international tax system. So in other words, how could we possibly compute a tax on the excess profit of a multinational company, in particular if it's a digital company, when there is uncertainty as to the way the profits of such a company should be allocated among jurisdictions? So once again, this example shows that the tax responses to the pandemic reveal some of the existing weaknesses that characterize the income tax system, both at the domestic and international level. I haven't looked at the time. I hope I didn't go over 10 minutes. I'll stop. Thank you very much for your attention.
Perfect, Alice. Thank you very much. I would say, Judith, it's your turn. and I will share your slides as soon as I can.
Hello, everyone. Can you hear me?
Yes.
Yes, good. So I just wanted to make a few observations following on from Alice's very good presentation, and you can see why I thought she should go first, or we thought she should go first, because she has set out an extremely good framework which she and John and Richard have worked out for considering these issues. But I'm going to drill down a bit and focus on the UK. Although it is notable that other countries are all having this similar issues, particularly when it comes to looking at the future. And I note that both in France and in the Netherlands, there have been papers put to their parliaments about the future of tax, whereas in the UK, we are still trying to work out our current support mechanisms. So we're a little bit behind on that publicly, though behind the scenes there's a lot of thought going on about the future of tax. And being a semi-retired person, I am now being asked to be on numerous committees. I think I'm on at least 3 committees to look at the future of tax, and I hope I'm not being too cynical, but I really doubt whether it's all going to be quite as wonderful an opportunity as people seem to think. So I want to focus on 3 things: modes of delivery, conditionality, and the future. And I want to talk about modes of delivery because, quite apart from the standard responses, such as deadline extensions, payment deferrals, loss carryback, which Alice mentioned and is discussed in their paper, we also have these very important methods of delivering help to individuals and to businesses, which the UK has put in place. And the UK response has definitely been one of the largest responses of all countries, both in terms of the effort and in terms of the amounts of money. And it's a very big story in terms of the surprisingly effective responses from both HMRC and DWP. We all thought the systems would collapse, and they haven't collapsed. And I think a lot of that has to do with the fact that a lot of pressure was put onto HMRC rather than DWP. In other countries, a lot of the help has been delivered through the social security systems, but in the UK, through the tax system. And that has been good in terms of delivery and the delivery working, but it hasn't been helpful in terms of being clear about the objectives, because it has mixed up the objective of meeting needs and keeping the economy going, and the link in people's minds between the tax they have paid in the past and their entitlement to help. And that is why we have a lot of talk about people falling through the gaps, because they're saying, I've paid my tax, and why am I falling through this gap? And it's why people are falling through the gaps, because the focus has been on the delivery mechanism. And we have used 2 kinds of delivery mechanism. We have used the tax paid by self-employed people in the past, and we have used the PAYE system, which normally applies mainly to employees. However, there are some types of worker who are caught by the PAYE system, agency workers and others, who have been covered by the coronavirus job retention scheme. And I think that underlines for me the importance of looking at methods of delivery rather than the employment definition in the future for dealing with this tax issue of what kind of tax people should pay and how much tax they should pay. Because it is quite clear that the only way we have of helping these people is by looking at whether they paid under the PAYE system. And that is where the company directors that Hugh mentioned earlier come in, because they have fallen through the system because they think of themselves as receiving remuneration. They think of themselves as if they were self-employed, because they really ignore the existence of the intermediary, of the company, in their own minds. And yet in law they are companies, and if they have paid themselves by way of dividends, this is not remuneration, it is not caught by the PAYE system, and they are not being covered by the mechanisms that are being employed. This is why I think that this will be a building block for the future, and clearly the Chancellor is thinking of it as a building block for the future, because we can think, as he says, in terms of, in the slide, he says, if people want to benefit equally from state support, we must all pay equally in future. So we are expecting some major changes in the areas of how we tax the self-employed, who are at the moment undertaxed and who are not paying enough national insurance given the benefits they're receiving. And we can see that there will be some changes to the way we tax owner-managed companies. This doesn't tell us how we're going to do it, but I think the important link will be mechanisms. How do we link that to mechanisms and not legal definitions? However, I do think there is this confusion between whether we're looking at whether we're paying based on past behaviour to help people, or whether we are simply assisting them. The other thing I would mention quickly is that those who are receiving benefits through the universal credit system are having a rude awakening as to the inadequacies of that system. And despite the adjustments that have been made to that system, we are going to see more and more people, as they fall off the job retention scheme, having to rely on universal credit and realizing how rudimentary and how basic and how low that support is, and how poorly it interacts with the return to work and starting to earn work, and how high the withdrawal rates are. And I think we're going to see a lot of pressure on our universal credit system as a result. And that conditionality is very similar to, I want to make a point building on what Ali said about tax havens, quite apart from the fact that it's a very foolish criterion, I think, for deciding whether to help business or not. Again, you have to think about what are the objectives. If the objective is to keep people in work and to keep the business going, who is going to suffer from not covering firms which are based in tax havens? Will it be the shareholders, or will it be their workers? And if it's their workers, are you not cutting off your nose to spite your face somewhat? So I agree with Alice about that. So we have to think about conditionality of these payments and how that fits into the underlying objective of the payments, and are we not getting somewhat confused about our objectives? And then I've got 2 more minutes to discuss the future, which is fine because I have no idea what is going to happen in the future. But it's clear that the flaws of the existing system have been highlighted. And we have a lot of talk about opportunities for a new social contract and wealth taxes and rebalancing the taxes on labour and capital. But all I'm seeing at the moment, or mostly what I'm seeing at the moment, is pleas for special reliefs and exemptions in the VAT area in particular, but elsewhere, and calls for low tax on business. So I am afraid I am not seeing that willingness to enter into a new social contract, but I hope I'm wrong. Okay, that's me done.
Great. So we have the usual ways of catching the attention of the speaker, including just unmuting oneself and speaking up. I don't see everyone, but I don't see anyone raising their hands. So I have a question for Alice and possibly Judith about this criterion which you criticize on tax havens. And you said that doesn't cover those firms that engage in aggressive tax planning without using tax havens, and it doesn't include those who engage in tax avoidance domestically. My question is, would it be easy to include these categories of firms, to exclude these categories of firms? Because one of your criticism is that it's difficult to identify what a tax haven is. I guess that applies for sure for these other categories. Either of you.
I'm happy to start the notes and then to let the words to Judith and John and Richard if they want to go on. So the picture I gave was a bit an oversimplified picture. So when you look at the legislative proposals that have been put forward, or even the law that have been adopted, you can have some conditions to exclude genuine transactions to subsidiaries located in tax havens, etc., etc. But from what I've seen so far, the conclusion is usually that those rules would be highly inefficient. So that either they would apply to a very limited number of companies, or that they that the list on which they are based is absolutely not objective.
And my point, my additional point, obviously I agree with Alice, but my additional point is, why would you want to do this if your objective is to keep your economy going now? And maybe in the future you might want to use this as some kind of stick to beat people and to and some kind of leverage to get them to behave in a different way in the future. But now the immediate problem is to keep those businesses going and keep employment going. And the fact that they are based in tax havens or they've entered into some kind of scheme is neither here nor there. It's not relevant to the current problem. I would say it's different if you're talking about whether they should be allowed to pay out dividends, for example. That's a different issue, because you don't want to be paying the money just to go straight to their shareholders. That would be a more sensible thing to focus on. And even the tax justice groups are saying that. The tax haven criteria is really not the right one at the moment.
Okay, so basically the other two wouldn't be good criteria either, I take it. Abby and Glenn have questions in this order.
It's Jeremiah's actually, but we're only using one account. So Judy, thank you very much. And tying back to actually Hugh's question from earlier, so I can see how the point of equalizing national insurance contributions between the self-employed and the employed is now going to be relatively straightforward, right? All the kind of white van man kind of, or at least much more straightforward than they found the last time around. But isn't there a much starker difference between the example Hugh gave and you then picked up on of the company director paying themselves dividends, where the income tax gap versus corporate tax and then the tax on the dividends on the shares is much more significant than the relatively small difference we see in terms of national insurance.
And I think the fact that they are not being supported under the current scheme and are very angry about it is going to make tax reform harder and not easier. That was the point I was trying to make. I'm worried about those people because they are not going to be compliant in the future unless some way is found of helping them now.
This is specifically the people paying themselves through dividends.
Yes, the company directors who take a low level of remuneration but are not entitled to the self-employed schemes because they're not self-employed, but are not entitled to very much job retention scheme money because they have received such low wages. And who are arguing that their remuneration now should be reclassified as wages, which of course was the whole reason why they decided to set up companies, because they didn't want that in the first place.
And so surely HMRC will be delighted to tax them backwards for since at employment rates.
I did suggest that, but no one picked it up. It's a problem, and I don't see it as an easy solution. And the fact that all I know, the Treasurer is scrabbling around at the moment to try and find solutions and ideas.
Thank you.
Glenn?
Thanks, Luca. Yeah, I had two questions. The first one was for Abby, Jeremiah, and Judith. And I was just wondering, is there much work going on the impact on the underground economy and the cash in hand, given, as Judith said, that the reliefs are being targeted to self-employed who have filed tax returns and employees. And then my second question was for Elise. And just wondering a couple of things. One was on the digital services tax that's being proposed. Are you hearing anything about sort of how that's fitting in with the current crisis? Is it, you know, I hear sort of this is a good idea. I hear this is a bad idea. And just also generally on cooperation, it seems like we've seen a real trend towards nationalized you know, sort of national views, and what's going to be the impact in terms of, you know, for the EU and for the kind of international cooperation we've seen?
Abby, do you know of work going on?
So in terms of cash in hand, I actually don't know of work that's going on trying to measure that. What we asked in our survey was something slightly different for people who've been furloughed. Were they still being basically asked to work informally? And so what we found was that 15% of workers said that they had been asked to keep working by their employers despite being furloughed. I think that something which is going to be quite interesting as we move to moving from basically the furloughing scheme being this binary 0-1 to supporting part-time work is also going to be on how practically do you actually monitor work hours and the extent to which actually there's some fraud going on in the system. I mean, I think it's definitely a good idea that we are transitioning to this supporting of part-time work scheme. I think it brings the scheme closer to like the German Kurzarbeit system, but it will have definitely some challenges, in terms of compliance. Sadly, our sample size at the moment is too small to like look in detail. Are there particular industries or occupations, for example, for which we see, where we see this this fraud going on? That's something as we collect more data, where we're hoping to look at if there are, particular areas that this is a problem in. No,
Should I go on with the other question? Yeah. I'll pass the word to John for the digital service tax, because he's been working on that quite a bit, and Richard could answer on cooperation because he was responsible for that part of the paper.
Something about both actually. So on digital service taxes, I suspect we'll see more countries adopting a digital service tax. So this is a tax on the gross revenue of certain highly digitalized businesses above a certain size. So these would be taxes on, Amazon, Facebook, Google, etc., etc. And there are these taxes on gross revenues generally are thought not to be good ideas for many reasons. But a number of countries are resorting to these kind of taxes because they are finding it harder to fix the corporation tax system. So my concern here would be that countries will resort to these quick fixes because there will be there'll be a political will to go down that route. Let's tax Amazon, Facebook, etc., especially because they've done so well out of the crisis. And that will be done instead of actually pushing ahead and thinking more serious in a more fundamental and in a more fundamental way that is lead to a better system for the long run. So I am worried we'll see more digital services taxes, number one, and I worry about it even more because I think it might move the focus from actually fixing the corporation tax system in a more fundamental way. And on cooperation, Richard will have more to say about this because he's been heavily involved in international efforts to fix the corporation tax system at the OECD. I think it could go either way. So you could see more cooperation among states, or you could see states taking unilateral measures. So they might want to take unilateral measures because they think, okay, now I really need revenue. I need to have a more competitive system to attract as much business and profits to my jurisdiction. Or else, we might see or else it might go the other way, that countries might take the experience as as a lesson in that we need to cooperate with one another. Cooperation might be harder if, as a result of the crisis, the big players find it harder to work with each other. So if, as a result of the crisis, China and the US find it hard to reach agreement, that's going to have an impact on international efforts for obvious reasons. Yeah, so I think on cooperation, it's going to go either way. So the crisis I can see reasons why the crisis might lead to more cooperation, and I can see reasons why the crisis might lead to less cooperation.
Judith or Richard, would you like to add something? Unmute.
Sure, I'll add two brief comments if I may. One is that the crisis is certainly putting much more pressure on global reform of the international allocation system. And the reason it's doing that is because the global reform that's being contemplated has been precipitated by an increased digitalization of the economy. And so it's pretty obvious that in the current crisis, there is a greater focus on getting digital channels to market and so on. So that exacerbates the problem at the very source of the reform effort. In terms of what it does to cooperation, I think that needs to be considered separately, both on the one hand in a response to COVID, and on the other on the wider undertaking of global tax reform. On the first point, the response to COVID, it is remarkable that, I was about to say overwhelmingly, but I think we can almost say exclusively, the reaction to COVID in tax terms, which has been very extensive, has been unilateral. Completely unilateral, yet in circumstances where a cooperative approach would be hugely beneficial. And what that represents, I think, is a different priorities and inability to agree on measures which one sees wider and so on. So in terms of an international cooperation to COVID itself, even though that would be quite beneficial, the prospects of certainly any deep outbreak of cooperation seem pretty low to me. On the wider question about what's the implication for wider global cooperation, and here I'm talking to the ongoing effort to completely overhaul the international tax system, I'm not sure if John is right and we're going to see some more DSTs, and he may be, then this would obviously be quite negative, and we can look forward to trade wars, because trade wars will happen if DSTs happen, I believe, as a result of US action. So that's a rather, slightly longer comment and less decisive than I'd intended. There you go.
Thank you. We have one question from Thomas Wu. Yeah.
Hi, Luca. Thanks. Thanks for the presentation. That was really helpful. Just had one question for Judith in respect of her comments on self-employed and employees and how mechanisms might become the more important link rather than legal definitions when formulating tax policy. Could you expand a bit more on how you think that plays out in the UK context and what you kind of meant by mechanisms and why that's being a bit more helpful?
Yes, well, that feeds into work that I've done, and also I've done it with written a paper with Abby and Jeremiah on this, but I've got a new paper that I've just finished on it as well, where I'm increasingly convinced that trying to have one definition of employment for all purposes, employment law, tort, whatever, as well as tax, is doomed to failure, because the objectives of the tax system are completely different. And all we're trying to do within the tax system is decide who to tax in certain ways, who to tax at source, and then have a mechanism for taxing them at source. And if that's all we're trying to do, we don't have to get into the complications of an employment definition. We can have a simpler rule for that without then distorting employment decisions through the tax driver, which is what I think is happening at the moment. So my argument is that far from aligning the two, so that we have one definition for all purposes, which is the way the government seems to be going after the Taylor report, we should actually be thinking about these as two very separate issues. And I think that's underscored by the way in which we've had to deal with the delivery of support in this current crisis. But it's not a new issue. This is not an argument that has arisen from the crisis. It simply has confirmed me in my view that that's the way to go.
Right, thank you.
Yeah, Abby and Jeremiah might want to comment.
Yeah, so I mean that's very much along the lines of the work we've done with Judith. I think it's also along the lines of the way we see the case law developing, right? For example, you look at some of the recent Supreme Court cases on vicarious liability, and actually there's exactly the kind of dicta you get, I think, from those cases. So
I have a paper which should be coming out in the King's Law Journal, looking further at that, which I hope to be able to circulate soon.
Perfect, excellent. And so until then, there's also our joint piece with Judith in the Oxford Review of Economic Policy. That all said, there's another sort of different story where you say, actually, what the support scheme at the moment shows is that any kind of bifurcation in the labour market is pretty artificial, right? And that, for example, in the minimum wage context, some countries like Poland have gone down the opposite route and actually abolished the binary divide and said there's just a minimum cost to wage, regardless of the legal form in which it's offered. So again, I think it's interesting. On the one hand, yes, in principle, I think I still agree with the point that we raised with Judith, that different categories need different treatment in different regulatory areas. On the other hand, I think there's also the case here for some more radical reform to say that at least for certain labour standards, particularly one where sort of identifying the duty holder isn't very difficult, you could say that this is actually the case for abolishing a lot of these binary divides that we've seen.
Yeah.
That's great, thank you.
Okay, we still have 2 minutes. If anyone wants to say something, conclude, or because if that is not the case, then as a chair, I will give the floor to myself, because I'm the last presenter for today, and Agatha kindly put on screen my own slide, in which you may notice that I cheated on the rules, because I put a hyperlink to the post on which this slide is based. On the other hand, I will not speak for 10 minutes, so that should compensate. And so this is it's a post that will, a long post that will become a short essay. And therefore I'm very interested in any feedback today, and that's why I will speak as little as possible. The idea is to do with corporate law what has been already done in many jurisdictions, or is being done even in the UK, with regard to insolvency law. So many jurisdictions have suspended some insolvency law rules, or made changes to them in order to cope with the crisis. And the idea is that there are things to do to improve the life of existing companies in the company law area as well. And the post, first of all, says a few things about how this should be done before identifying examples of what could be done. And the idea is that it should be done intuitively with rules that preferably just suspend the application of existing rules, while creating new special rules as rarely as possible. This is because this is not the time to come up with new solutions, which may be hasty and not well thought out, so the dangers of getting it wrong are greater. There should be a sunset clause, so these rules should only apply, not necessarily until the end of the health crisis, possibly should be longer than that, because the economic crisis will lag behind, will last longer than the pandemic crisis. But there should be still a sunset, which will therefore require policymakers to ask whether to keep the rules in place, and if they do nothing, they will just cease to be enforced. And finally, these should all be default rules, because the main purpose is to keep companies afloat, and it should be possible for individual companies to signal to the market that they are fine, that they do not need a special treatment even during the crisis, and therefore it should not just be possible but even easy to opt back to pre-crisis rules if companies so think it best for themselves. In terms of the contents, there are two areas. The first one is the idea that companies are in survival mode and they have to find ways to raise cash basically as easily as possible in the form of debt or equity. And also we should make companies and their management's lives easier in a context of extreme uncertainty like the one we are living. So when it comes to survival, first we can think of suspending some of the rules on capital increases, new issue of shares, or even when these involve related parties, whenever these rules impose either burdensome requirement or time-consuming one. So when they make it harder to raise cash quickly, which leads to, for example, relaxing requirements for shareholder approval, or even to grant preemption rights to existing shareholders, because that takes a minimum of 14 days according to European rules. And of course, that doesn't mean that everyone will have a license to do anything, because there will be remedies ex post if these new freedoms are abused. And another area is possibly the mandatory bid rule. Many jurisdictions exempt from the mandatory bid rule when an individual company is at the risk of going insolvent. The idea here is that at this stage, practically all companies are at risk of going into insolvency, and therefore there may be a general case, a case for a general exemption, of course, temporary and default. In terms of coping with uncertainty, the idea is that directors face an increased risk of making the wrong choices in good faith, and wherever corporate law around Europe, my focus is mainly on Europe, make the risk of liability a serious one for directors, if only once the company, if the company goes bankrupt, then even if the action hasn't been taken, the decision hasn't been made on the in the twilight zone, there should be no second guessing or less second guessing of directors' choices, because we may soon be litigating this behavior, hopefully soon, but definitely in some jurisdictions it will be the case that these cases will be litigated after we are back to normal, and it may be easy to have a hindsight bias even in those circumstances. And finally, the other area where something could be done is in terms of protecting incumbents' control and generally making hostile bids less easy. That's because, not only because it will be distracting for a company to be the subject of a hostile bid in times in which all the focus have to be on keeping the company afloat, but also because in times of extreme uncertainty, it is easier for the market to misjudge companies' management decisions and investment choices and strategies, so that it may be easier for a company to have a market price that punishes perhaps long-term or idiosyncratic strategies that may be the best, but the market doesn't see as such. And to conclude, again, this shouldn't be permanent changes, but it should be the occasion to introduce permanent rules of regulatory governance that we allow company laws to be tweaked if, God forbid, another country crisis such as this will materialize in the future. And that will be important also to reduce the risk that these tweaks are made permanent later on. So I took more than I should have, but now I'm done. And so anyone who would like to talk? So I see Tom Wetzer's hand, and then John Bell, and then Paul Davis.
Hi, Luca. Yeah, great paper or post or lengthened post. So you spoke about the risk that the freedom under this pandemic-resistant corporate law might be abused, and then the correction of ex-post review being applicable. I just wonder to what extent the decision to even trigger this, specialized corporate law, that decision might be subject to review as well. And particularly because it's so easy, it should be so easy to opt back. And if that's the case, if that decision is subject to review, and if the risks of ex-post bias could be potentially large, would then directors of companies not be hesitant to trigger or not opt out of this pandemic-resistant corporate law immediately?
So you're saying that they might fear liability for opting back?
Yeah. No, sorry. They might fear, so if they decide to relax corporate law duties, that decision might be subject to liability, and that's the liability that they might fear. And obviously, because of the way you structured it, that has to do more with the opt-back decision than with the opt-in decision.
Okay, I get it. Sorry. Yeah, that's a good point, but I think that if also the director's liability tweak is introduced, then you would focus on abuses, so on behavior that is self-serving, anyhow in breach of the duty of loyalty, and I would hesitate to even give a free hand on that side. Of course, ex ante you can do it, you can relax related party transactions rule, but even saying that there will not be review if someone has arguably acted in bad faith and to enrich themselves, that is a little bit too much. John?
Hey, Luca, just a small point, and this might be because I'm out of touch with corporate law these days. When you started your presentation, I expected you to mention something like wrongful trading. Was it not included for a particular reason, or maybe it doesn't fit with what you were working on?
No, it is not included because it's at the border between corporate law and insolvency law. You can categorize it as both, but when I wrote this, already many jurisdictions were looking into wrongful trading rules, so it was already a well-trodden path that there should be a suspension of rules in that area, which is now what the government's bill on insolvency in the UK also has proposed. New Zealand has done it, Australia has done it, and Germany too. Paul?
Yeah, thanks, Luca. That was very interesting. I was thinking about fundraising while you were speaking, or focusing on what you said about fundraising. And it is, as you say, a question of how far do you want to go? how far do you want to relax the normal requirements? Or to put it another way, are we doing enough actually to make fundraising more easy, or is it just a sort of something which appears to be helpful but probably isn't? And linked to that is the question of whether you need to think about not only, or need to include not only ex post liability suits by shareholders, but also ex post prosecutions by the public authority. So what came to my mind was the prosecution for fraud of the director of Barclays Bank, who in the last crisis we had, the financial crisis, carried out a very astute fundraising which saved the bank from falling onto the cost of the treasury and kept it independent. But they were then subsequently prosecuted by the Serious Fraud Office for fraud. Now, I'm not quite sure what the fraud consisted of, but I think it was simply not revealing the full details of the arrangement they'd done with Qatar to raise money from them. So, I mean, if that's the sort of thing that needs to be done for effective fundraising, I wonder whether the measures you mentioned go far enough to achieve the result one might be looking for.
The point is well taken and similar to Tom's. So I guess that's a point I have to reflect more about. And sure, there are many ways in which things can go wrong when you do things hastily. But at the same time, how can you propose just to give a free rein on fraud?
Yeah.
Can't write something like that. I would say I see Horst.
Maybe I elaborate quickly. So when listening to your presentation, thanks very much, Luca. That's very interesting. I just thought that it seems to reflect a kind of bias for the status quo in two senses. A, you are kind of assuming that what we have right now is efficient. And B, and that's more important, I think, you are also assuming that the crisis is not changing the preferences, which are the basis for the welfare function to judge corporate law. However, that may well happen. So it may well be that the crisis is going to change how we conceptualize the costs and benefits of corporate law and what the preferences of stakeholders are with respect to corporate law rules. And because of this, I think you probably should make explicit that you're not looking into changes that may be triggered by these fundamental changes in preferences, but you are assuming that the preferences of the stakeholders with respect to corporate law rules are remaining constant.
That's a great comment. Thank you. Definitely, I should make that clear. It's perhaps for another paper a little bit later, because now speculating on how things will change is hard, as Judith also hinted at before. But it's funny you mention. So you take my paper as assuming that the current rules are efficient, because I actually focus mainly, not exclusively, but mainly on rules that I have criticized in the past as inefficient. So I fear the opposite critique, that is that I sort of in the mood of not wasting a crisis and arguing that this is the time to do something about that stuff that wasn't right before. But maybe I should make also that more explicit than I think already it is, and there is no assumption of that kind. I think that there's a stronger case now for some tweaks that may be justified in general, and a strong case now for some suspension of rules which may otherwise be justified. Abby or Jeremias?
Given the topic, it's me. Lucas, think I really like the paper. The concerns, I think, may be similar to the one that Tom raised, which is about how we draw certain boundaries. So particularly when it comes to insulating the rectors from liability in, you know, I mean, again, a slight difference in the continent, but in most jurisdictions, directors are already pretty well insulated against liability. So I'd be concerned that lifting that threshold further, I don't know, put it differently, can you give me an example of something that you think might be a reasonable action for director to take in the COVID crisis that would expose them to liability under the current regime that you have in mind here?
Not exactly. No, what I can say is specifically the rule that I have in mind, which is made explicit in quite a few continental European jurisdictions, which is the duty to act on an informed basis. Mm-hmm. That is, for example, spelled out in German corporate law and Italian corporate law. So that in general is a tricky duty, because it's easy exposed to find some facts that should have been considered because of the reality, so the real world made them significant in terms of causing negative consequences for the firm that were not considered by the board. I think in these days in which every month or so we know much more about what's going on in terms of the science of COVID and how people react to it, and what the meaning of government guidance is, and so on and so forth, then that may lead to making omitting the consideration of information that exposed may prove material or maybe judge material with hindsight bias. And so I think it's not an example that like doing something specific, but it's an area of risk that I think.
But so again, with that example, Luca, it's my sense is that wouldn't necessarily be a problem in the current rules, right? Because if you can prove that a particular kind of scientific information or guidance wasn't available at the time of the decision, surely you couldn't expect somebody reasonably to have taken that into account in the first place. So I think just to sort of strengthen that argument and not just making it sound like a sort of, hey, we should have a business judgment rule in Europe, I think having some specific examples related to the crisis that explain what the kind of changes you have in mind are might be helpful in terms of developing that argument.
Yeah, okay, so that's very well taken. It's a great suggestion. I will spend the last minute telling you about what happened in some areas of Lombardy. There were one hospital in Veneto and one hospital in Lombardy. The one hospital in Veneto sent people home in the very first days of the crisis. The hospital in Bergamo, or in the province of Bergamo, took all the ill people in. Mm-hmm. And that was a disastrous choice. We have found out after a few weeks. Now it seems crazy to take people in. At the time, it wasn't. I mean, it was the wrong choice for sure, but one that is also understandable from a medical ethics point of view. And so now there is a high risk in Italy that the people who made those choices will be liable towards for torts reason or for damages to the state or from a disciplinary perspective. So that is perhaps a non-corporate law example of how, even in the absence of scientific evidence, but in an area that is close to it, you can get it spectacularly wrong in good faith and not necessarily being fairly then prosecuted or be subject to lawsuits and so on. It's exactly 2:00, and I'm the chair and the presenter, so I don't want to abuse anyone's time. And therefore, I would, unless there's someone who really wants to jump in, I would like to thank Abby and Jeremias, Alice, Judith, Richard and John and myself in the cases of other excellent presentations, and thank you all for the discussion. That was very, very helpful. I think I say that on behalf of all the speakers. Thank you
to you, Luca, for chairing and bringing us all together. Thank you to you as well for organizing it.
See you hopefully next week. Horst will basically lead the session. Maybe I formally chair it, but it will be more on commercial law aspects, all of it. So thank you very much. Bye-bye.
Thank you very much. Bye.